Generally not. The California Code of Civil Procedure provides exemptions for people who are filing for bankruptcy. On top of the vehicle exemption, which is $7,150, you also have access to what's called a wildcard exemption, which is valued at $26,500. These are exemptions that we use to protect equity in assets. Now, more often than not, the debtor who is filing for bankruptcy has financed that vehicle, which means that there's still money owed on it. So we take what the vehicle is worth, deduct what is owed, and more often than not, that falls well within the vehicle exemption. So no, you will not lose your car if you file for bankruptcy. In California, you have $26,500 of what is referred to in wildcard exemption. This can be used for any asset, be it a home, a vehicle, a block of gold bullion, an old record collection, or even antiques. But those assets can be protected in bankruptcy. Absolutely not. Pulling money from a retirement account has dramatic tax consequences, and in bankruptcy there are specific exemptions to protect all of the resources in those accounts. You can file for bankruptcy and still have all of your retirement money. Pulling money out costs you $1.45 on the dollar. It just doesn't make sense. Absolutely no question about it. Payday loans can be discharged in bankruptcy. It's an unfortunate situation in our country and in our economy that people need to rely on payday loans, and what they quickly inevitably discover is that the payday loans themselves become the enemy. But yes, these can be discharged in bankruptcy. Filing for bankruptcy, as opposed to allowing creditors to continually report you delinquent, is essentially akin to pulling the Band-Aid off in one fell swoop. Yes, it hurts for a short period of time, but after that, the healing begins. And that's the important thing. You have to remember that your right to file for bankruptcy was carved into the Constitution in Article 1, Section 8. It was there long before your right to bear arms, but yet it's not talked about as much. The idea is to give consumers in a free market economy who have taken on risk a fresh start so that they can go and begin again. Time and again, we see people who have borrowed money from retirement accounts, taken out title loans on cars, payday loans, done balance transfers between credit cards to inevitably end up in the same position they were at the beginning. Filing for bankruptcy ends it all in one fell swoop, and you can begin your fresh start in as little as 3 months. The discharge of tax debt and the removal of tax liens in bankruptcy is a very complicated and scientifically calculated issue. Nobody should try and do this on their own without consulting a qualified bankruptcy attorney. And it should be explained to the bankruptcy attorney that the major reason that you're looking to file for bankruptcy is to seek the discharge of these tax debts. The general rule in bankruptcy is that tax debts can be discharged as long as they're 3 years old, and as long as you filed the return at least 2 years prior to filing the bankruptcy case. This is often a very complicated calculation, and you should consult an experienced bankruptcy attorney before attempting this. Bankruptcy law provides a number of exemptions to people filing for bankruptcy. One of those is the homestead exemption. This ranges in value between $23,000 and $175,000 for each individual debtor, depending on certain circumstances. When considering filing for bankruptcy, if you are a homeowner, you should contact an experienced professional to have your case evaluated. Under no circumstances should you file bankruptcy on your own without doing so. The exemptions provided under California law are both generous and limited all at the same time, and there are a number of qualifications in order to determine the exact value of your exemption for your home. The bankruptcy process is fairly simple and fairly straightforward. Once the petition is prepared, it is electronically filed with the bankruptcy court. The court automatically assigns both a trustee and a judge to your case. If all goes well, you should never have to meet the judge. You will, however, have to meet with the trustee in your case. The court will automatically assign the trustee and set a date for what is known as your meeting of creditors, which will occur within 30 to 45 days of the filing of your case. You will have to appear with your attorney to answer questions from the trustee, and as well as an opportunity for creditors to appear and ask you questions pertaining to the nature and location of assets. This is one of the reasons it's advisable to have an attorney present at said meeting, because often creditors will try and ask questions outside the scope of examination, and the trustee is not your advocate and cannot help you with this. Once the meeting of creditors is concluded, you will receive your discharge within 60 days. This will mean that all of your pre-petition debt obligations will be discharged. Within 15 to 30 days after that, the court will close your case, and that's it. The average Chapter 7 case lasts anywhere between 100 to 120 days. Your participation in the case, though, is simply front-loaded. You have to provide the information to your attorney such that he can populate your petition and schedules, and you have to appear at your meeting of creditors. But after that, your involvement should be fairly nil.